بسم الله الرحمن الرحيم الحمد لله رب العالمين وصلى الله وسلم وبارك على سيدنا ونبينا محمد وعلى آله وصحبه وسلم تسليما كثيرا. اللهم فقهنا في الدين وعلمنا التأويل وألهمنا رشدنا يا رب العالمين. My apologies for the excessive delay. We're still in the section on Idda, and we stopped at what are the implications of Idda? Right? So if Idda is required, then what is due upon her? So we reached وَعَلَى الْمَبْتُوتَةِ والمتوفى عنها زوجها إذا كانت بالغة مسلمة الإحداد. Right? So the ala is used for shurut and huquq, right? For conditions, right? And rights, right? So in a situation like this, in عليها, meaning it is upon her that these are the conditions, these are her responsibilities, rights and of course responsibilities, right? And this happens in other types of huquq, like in transactions, for example, right? And you say, بعتك هذا على 50 dinar, for 50 dinar, right? Or you can say, بعتك هذا ب50 dinar على أن أدفعه بعد شهر. I sell this to you for 50 dinars on condition that you pay me in a month, for example. So ala is used for conditions. The other thing that comes up immediately is that people very often get lost in terminology. Okay? So the talib ilm would have, would have access to that which explains terminology to them. And we mentioned that's why the Lubab, though a great commentary, is not an explanatory commentary per se. An explanatory commentary is that which breaks down the words, explains them, etc. Which is why the Indian commentaries are quite useful in that. And also, Mawlana Ashiq Ilahi's work, At-Tasheel al-Daruri, is useful for that as well. At-Tasheel al-Daruri min Masail al-Quduri. But there's also, of course, a separate thing, which we'll discuss after the class, that there are dictionaries of terminology. Right? So, على المبتوتة, right? Who is the mabtuta? Okay. There's one of the challenges with the mutun is that they talk about the concepts. So, of course, that's part of the benefit of studying a text in a class. What is the mabtuta? Thankfully, mabtuta is not a word that's used commonly. So it's something you need to understand terminologically, right? That the talaq is of two types, right? There's talaq raj'i and the other type is talaq ba'in, right? And al-mabtuta, anyone find what mabtuta means? What does Saqib al-Jawhara say? Does he define it as well?
I don't think so.
Good. Right? So talaq al-bat is a talaq al-ba'in, right? 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 So, على المبتوتة, the one in the talaq ba'in, right? والمتوفى عنها زوجها, and the one whose husband has died, if she is an adult Muslim woman, because if she's a child, this is not due, and if she's a non-Muslim woman, then she cannot be held to the limits of the deen, and it gets tricky. What exactly is required from her? Al-ihdad, as she has to do, ihdad. Okay? And this ihdad, and we'll see what is ihdad, right? Which is that you hold yourself back from a whole range of things. right? And this is not the haqq of the zawj, right? This is haqq al-shara, as a commentator mentions, right? Even the husband says, look, I waive you from having to stay at home and do this and this and this and this. It's not his haqq to waive. It's a haqq al-shara, as the commentator makes clear, right? And the wisdom behind this, as the commentator mentions, is إظهارا للتأسف على فوات نعمة النكاح, is to manifest one's regret, تأسف, in missing out on the blessing of nikah. Right? So there's lessons in it. How is ihdad done? It's almost like he's giving us a functional definition. Ihdad. So as if you say, وَمَا هو الإحداد? What is ihdad? بِتَرْكِ الطِّيب, by leaving perfume. Right? وَالزِّينَة, and adornment. Right? So a طِيب refers to using of perfume or other types of ways of, making one's appearance, smell and appearance pleasant. وَالزِّينَة, which is adornment, right? Such as بِحُرِيٍّ, right? By using jewelry or fine clothing, such as harir, right? And fine clothing, right? So one would wear plain clothing. Fine clothing would be clothing that one does not wear day to day, right? And that would depend on custom as well. So it's one's regular clothing, but the zina would be what one would wear in special occasions. For example, when one would dress up, one would not do that. Waduhn, right? Right? By using oil, and in our times, like creams and so on, right? Wal-kuhl, and to avoid using kuhl in one's eyes. Illa min udhr, unless it's from some medical reason. This would apply to all the above. So for example, if someone has dry skin and they need to cream because they have dry skin, that's different from using cream to beautify oneself. Right? So that's why he says illa min udhr. The comment says raji'un lil jami', right? And that's always with things like exceptions. Illa. Right? One always has to think, what does this go back to? Does it go back to just the last thing, or does it go back to the whole set of previous statements? Okay. وَلَا تَخْتَضِبُ بِالْحِنَّاءِ. She does not dye herself with henna, like her hands, for example. وَلَا تَلْبَسُ ثَوْبًا مَصْبُوغًا بِعُصْفُرٍ وَلَا زَعْفَرَانٍ. And she does not wear garments that have been dyed with usfur, which is sulfur, or saffron. So these are types of adornment. These are bright colors that would be used for festivity, for joy. That's not becoming the state of ihdad, of being in the state of idda. So this is a basic summary of ihdad. Now if you look at we mentioned last time about Quduri Basha's work, Al-Ahkam al-Shar'iyya fi al-Ahwal al-Shakhsiyya. Around item 322, it summarizes the ahkam of the ihdad. I might have the number wrong, but you can find that there. It's quite useful because it summarizes the various rulings. Okay. So it's understood from what he said before, right? That إذا كانت بالغة مسلمة, but he mentions it explicitly. ولا إحداد على كافرة. There is no ihdad due on a non-Muslim woman. Okay? Why? Because لأنها غير مخاطبة بحقوق الشرع. Because she is not addressed by the rights of the shara. Right? The first thing with a non-Muslim is that they're called to Allah subhanahu wa ta'ala first. Right? Now in public, there are public limits that they have to respect. Right? To maintain the general public decency. Where that limit is put returns to the discretion of the ruler. Right? And example, does a non-Muslim woman have to wear hijab in a Muslim country? That ultimately is a hukum from the siyasa shari'iyya, from what is due shara, because we know slave women don't have to wear hijab, right? So what would apply to that returns to the judgment of the public interest. Okay. ولا على صغيرة, nor is ihdad required on the saghira, who is someone who's not reached the level of bulugh. Of course, to reiterate that, as we did earlier in marriage, that something being legally permissible would not necessarily, something that's in itself permissible in the Shara does not necessarily mean that it would be practically permissible in any particular societal circumstance. Right? But in most Muslim countries, there are age limits established on marriage with the approval of the ulama because of obvious reason. Harm is averted. Harm is averted. وَلَا عَلَى صَغِيرًا. Now, methodologically, if you compare this with some of the other mutun, the mention of these 2 points, the later ulama would say that there's redundancy here. The defense of Imam al-Quduri would be that مقام التعليم مقام التصريح, that the station of teaching is a station of mentioning things explicitly. But in a matan, the fuqaha mention an important principle, that مفاهيم الكتب حجة, that the indications of books are a proof. Right? Which is why you find not a lot of the later scholarship of the Hanafi method is based on Mukhasar al-Quduri. The great works were written on the other mutun in the later method. Right? Now the Lubab is a very significant work, but you see what other major works that became references in the madhab historically, like from the year 600 onwards, they're generally not included because its preciseness and its tightness is not like the other mutun, but it has clarity, which is why it has been the first text studied. Right? Because what needs to be clarified, he makes it explicit. Sometimes that redundancy is praiseworthy. Right? وعلى الأمة الإحداد, a slave woman needs to make إحداد. And then he says وليس في عدة النكاح الفاسد ولا في عدة أم الولد إحداد. In a idda is due in a nikah fasid, as we mentioned, right? Where a nikah took place, but some of the conditions were not fulfilled. There's a lack of witnesses, for example, etc. And of course, this is akin to zina and is very serious. But what is required from a nikah fasid? Idda is required. But that idda, because it did not take place in a state of the ni'mah of marriage, because the idda, the nikah fasid, the corrupt nikah, does it constitute marriage? It's not actually nikah. Right? So the idda is has 2 aspects, right? At one level, you want to make sure that there's bara'at al-rahim, right? And there's a haqq of the shara. But there's a practical wisdom in it. The wisdom, the benefit component of it, which is to recognize the ni'mah of marriage, does not apply in the nikah al-fasid, right? And he explains that in the commentary, right? Another example of where the wording of Imam al-Quduri here is not necessarily the most spot on is that, okay, if a woman is in her period, is in her idda period, can she approach somebody for marriage, and can someone approach her for marriage? Now, in both of these, can be done صريحا أو دلالة, explicitly or by indication. And we'll see the answer to both cases. So he says, لا ينبغي ولا ينبغي أن تخطب المعتدة. He says it is not proper that a woman in Idda be approached for marriage. Khitbah is the marriage proposal. When the marriage proposal is accepted, in that state of khitbah is the engagement. They're engaged. There's an expression of interest of marriage and an acceptance of that interest in marriage. That's khitbah. That is not marriage. It's a commitment. A commitment is so it's legally like a promise. It's haram to make a false promise, but it is permitted to break the promise. But it's makruh to break a promise unless there's good reason. But you can change it. But someone can change their mind. Right? So he says it is not proper. Now, yambaghi is normally used for recommendation or dislike. Yambaghi generally is used for the mustahab. It is proper to normally indicates recommendation. And la yambaghi is normally used for that which is improper, somewhat disliked generally. But here, Imam Alam al-Maydani rahimahullah says, بل يحرم. Okay? It is haram. It's haram. Okay? So the now ينبغي, لا ينبغي is also, it should not be done. Right? Now in English, they say one of the words that should be struck out in legal writing is the word should. Why? Because should is fuzzy. If it has to be done, say must. If it's recommended, say it's recommended. Okay? But the defense of the early scholars, that they're addressing people who have one, the background on the religious texts, and they have a thaqafa diniyya, they have a religious education, so they would understand what's being said. Right? So, okay, we should say he's wrong in his expression because it's sound. Yet, لا ينبغي, it should not be done. Should encompasses recommendation, your dislike, and encompasses the haram should not be done as well. Okay? But, so it's not aib on Imam Quduri, but it's aib, but it's because of our qusur al-fahm, our lack of understanding, more precision is required. Right? So, a woman in a state of idda, and the commentator said, should not be approached for marriage, whichever idda it may be. But he says, وَلَا بَأْسَ بِالتَّعْرِيضِ فِي الْخِطْبَةِ. There's nothing wrong, لا بأس, there's nothing wrong with indicating interest. Right? And that's referred to in Surah Al-Baqarah, verse 235. Right? Right? So mentioning it indirectly, right? Right? And they mentioned that Ibn Abbas said, for example, it's to say, I'm interested in getting married, in a general sense, in front of a woman, for example, right? Okay? Or they mentioned the actual wording is or to add وَلَوَدِدْتُ أَنْ يُيَسِّرَ لِي إِمْرَأَةً صَالِحَةً. I wish that Allah would facilitate for me a righteous woman. In the presence of the person without telling them, I want to marry you. Right? That's indirectly. So this is not wrong. Now, However, the ta'rib, right, the ta'rib, this is only, now this is an important condition, right? That this is هذا في المعتدة لوفاة فقط. This is only for the one whose husband has died. لا بأس بالتعريض. There. It's an important condition. دون غيرها. And this is in Quduri Basha. I believe I have it written, it's number 7, but I do recall that my numbering here, I don't know, my number may be wrong, right? So this is, the ta'rib is for the one whose husband has died. One can make ta'rib indirectly. So indirect. Right? Ta'rib, so you can't make a direct proposal, but you can indirectly express general interest, but not specific proposal. And then he tells us of the other rulings related to a state of idda. So he says, وَلَا يَجُوزُ لِلْمُطَلَّقَةِ الرَّجْعِيَّةِ وَالْمَبْتُوتَةِ الْخُرُوجُ مِنْ بَيْتِهَا لَيْلًا وَلَا نَهَارًا. It is not permitted for the one divorced in a talaq raj'i or a talaq ba'in, the mabtuta, to leave home whether by night or by day. Right? Why? Because it's wajib on her husband to provide for her when she's divorced. Right? The house the woman lives in is mansub ilayha. Right? That's her. The husband has a responsibility. The house, if he bought the home, the house belongs to him, but it's her bayt shar'i. Right? So he has to provide for it, but he has to continue to provide for it during the idda. He has to provide a place for her to live, has to feed and clothe her, as he did during, even before that. So she should have no reason to leave the home in that sense. This but the reason for this being that so this is related to the rulings of idda and her not needing to leave home. Why? Because the husband is obligated during the idda to be providing for her, which is why the ruling differs from al-mutawaffa anha zawjuha. So he says, وَالْمُتَوَفَّى عَنْهَا زَوْجُهَا, the one whose husband has passed away, تَخْرُجُ نَهَارًا, it is permitted for her to leave by day. وَبَعْضَ اللَّيْلِ, and some of the night, till when it is safe for women to be outside. Right? Because her husband's dead. Right? How can he provide for her when he's dead? Right? So she may need to leave. Right? To the extent of her need for islah al-ma'ash, to take care of her provision. But the commentator mentions that if she has sufficiency of provision, then even the one whose husband has died, in her iddah she cannot leave. Right? As mentioned in Fath al-Qadir of Ibn al-Hubam. So that's one ruling, right? About leaving home. Second ruling is وَلَا تَبِيتُ فِي غَيْرِ مَنْزِلِهَا. She cannot go to sleep in other than her residence, which is Bayt al-Zawjiyya, which is where she was married. what is her manzil? He explains. وعلى المعتدة أن تعتد في المنزل الذي يضاف إليها بالسكنة حال وقوع الفرقة. It is upon the woman in Idda, meaning it is wajib upon her, as the commentator makes clear. This usage of ala, pay attention to it, right? Because ala is really isti'la. It's something that's above you. So what's on you, it's as if it's a burden you bear, right? It's a responsibility. And so say alayka, it is upon you too, means it's your responsibility. Okay? That she be in Idda in the house that was ascribed to her by residence, meaning where she used to reside. حال وقوع الفرقة, when the separation took place, the separation of divorce or fasakh, whichever of the ways the marriage was terminated. Okay? So the commentary says, so even if she was divorced elsewhere, so they're at a restaurant, he got fed up with her, he divorced her, she has to return immediately. She has to return immediately. There's primary text related to that. So if she was traveling, and so what if they're on vacation in Italy, and she thought it would be really funny to pour coffee all over him. So she did. He divorced her. She needs to take the next flight home. Right? She can't finish off the vacations and go. Unless they can't afford to do that, then as soon as reasonably possible without undue hardship. Of course, he'd have to pay for the flights because he chose to divorce her after that, right? So that's right. Now, what if he died and the house now is part of his estate? So what happens? It gets divided up amongst the inheritors. She's only one of the inheritors. So he tells us that the fa here, the fa often makes tafsil. But when you see a fa making tafsil of it, it's telling you, so what are the implications of this? You have to first gather and say, this applies to the al-mu'tadda. So there's different cases of idda. So what happens? Okay, husband's still alive. If it's talaq raj'i or ba'i, she has to stay in that house. But the idda also, al-mu'tadda also encompasses whom? Al-mutawaffa anha zawjuha. In that case, it can be complicated. So the fa relates to that third case, right? فإن كان نصيبها من دار الميت لا يكفيها. If her share of the house of the deceased, this is في حق المتوفى عنها زوجها, the one whose husband had died, is not enough for her. فأخرجها الورثة, so the inheritors force her out of the house. من نصيبهم, from her share. So, because of course that's why estate division is tricky. So let's say someone, if you just like a challenge in dividing things is who owns what. So let's say if Shaykh Yusuf and I bought an ice cream cone 50-50. Right? So you have the cone and you have the ice cream. What's the problem there? What's the problem? No. What 50% do we get? So let's say I love ice cream. So I'll take the top half, you take the bottom half. There's no ice cream there. Right? So it would lead to dispute. Because technically, when you get something 50-50, both of us have ownership of 50% of the whole thing. Now we either divide it up by mutual agreement, or we have to take it to be divided. Nobody can enforce their sharing upon another. And if you're in a situation where you're forced to do that, then you have to use adl, justice. Like you have to cut it down the middle, for example, or as close as you can. Or you could agree on muhayyada, on splitting. You take a bite, I'll take a bite. So, so that's always a tricky thing. So now, let's say someone inherits 30% of a house. Which 30% is hers? A good estate division would apportion things in a manner that gives equity. Right? That gives equity, but also so she'd have access to her room, for example. But let's say they said 30%, we need the rooms. Dabbiri hal. She's one, they're many. Okay? So they tell her she has to leave. Of course, this is not the right thing, but if it happens, it's not big enough. It was a small house. It's just like in a modern condominium. Like, there was a house in Toronto. And recently, something came up for $800,000 in Toronto. In the news this morning. $800,000 in Toronto for a garage. Someone was selling off their garage. One car garage in downtown Toronto. Not the home for $800,000. Just the garage itself was converted into a loft or whatever. Okay? So let's say she inherited something like that, but it's being split between different inheritors. It's, you have 30% of this, we'll send you the check for the rent when we make money on it. Right? So intaqalat, she moves from there. And then she has a right to choose where she wants to go to. Then a place that's befitting. Right? Now there's some other rulings, if you see in the commentary, a line down, he says, ثُمَّ إِنْ وَقَعَتِ الْفُرْقَةِ بِطَلَاقٍ بَائِنٍ أَوْ ثَلَاثٍ. If the marriage ends due to a talaq ba'in, an irrevocable talaq, even one pronouncement, or a threefold pronouncement of divorce, because that's as ba'in as it gets, then there must be something to separate a sutra, a barrier between the two, because no raj'a is now possible. And then there's nothing wrong with it if there is some kind of sutra. So they have to keep separate, because they cannot be in khalwa together in that situation. Right? And there, if he's an upright person, she can remain. They can both share that apartment. And the sutra would include she's in one room and she keeps the door closed on herself, right? So they're not alone together anyway. And if he's an upright person, they can share the apartment during their idda. She feels safe from him. Right? إِلَّا أَنْ يَكُونَ فَاسِقًا, unless he's corrupt. يُخَافُ عَلَيْهَ مِنْهُ, and he is feared for. He's feared for. Then she would leave the house. Though, right? وَالْأَوْلَى, and some said الْوَاجِبْ, is that he must leave. Right? So if they have a small house, and let's say, there's cases where they hate each other, but they can't keep away from each other. Just happens. That's life. Right? They've divorced each other, and, but they keep, people are complicated and conflicted. So then it says الأولى أن يخرج هو ويتركها. Right? And some said this is wajib, because it's her right, her responsibility to make idda there. So if someone has to leave, the default is that he leave. The reason he mentions that if he's fasiq, because he is fasiq, he doesn't care about the limits of Allah, then he may not agree to leave. Right? Then, she doesn't have to put herself in a position of harm. So what does she do? Right? Her first duty would be to request that he go somewhere else. But the whole thing is she's afraid that he's going to not respect the boundaries of khalwa and avoiding zina, etc. So she's afraid from him, he's refusing, or she thinks she's going to refuse, then she can leave. Right? Then she may have to leave. Right? and they're just tempted to have a third party there from his side or from her side, or agreed upon third party. They mentioned that, right? And he says, ولا يجوز أن يسافر الزوج بالمطلقة الرجعية. The husband cannot travel with his wife if he divorced her with a revocable divorce. So, he divorced her in Canada, he was planning to move to the US. So, okay, let's move together and we'll settle there because of the sake of the children's custody, etc. Hold on. Now, the Idda is the haqq of whom? And we say it's haqq al-shara. Of course, what we mean is haqq al-shari, is the right of the lawgiver. Allah subhanahu wa ta'ala. It's haqq Allah subhanahu wa ta'ala. Right? So, the command of Allah is a divine interruption based on your choice, on your plan. Right? So you guys say, well, I already had planned the vacation, etc. We'll travel anyways, and she'll do idda during the vacation. Doesn't work. Right? So it's only raj'i. No, why? Because right? Because of the implication of Allah subhanahu wa ta'ala's words in Surah Al-Talaq, verse 1. Right? وَلَا تُخْرِجُوهُنَّ مِنْ بُيُوتِهِنَّ. Do not take them out from their homes. Now, ikhraj, they say ikhraj can be forced expulsion or just taking out. It encompasses both. Okay? And the hadith that works on, right? And this issue has been specified as relating to the one from a divorce and the talaq ba'in. Why? In the raj'i, because the talaq ba'in, there is no discussion that you can't travel with her. Okay? Because the marital bond there becomes, then the rules of idda, of khalwa would apply, etc., etc. Okay. Now, the talaq al-ba'in requires, if a talaq ba'in happens, how do they get back together? With a new nikah. So that's good to keep in mind for the next issue. Okay? And just to practice these things, because this issue is straightforward, but in going through fiqh, like when you come to something like this, إذا طلق الرجل امرأته طلاقا بائنا. If the man divorces his wife with a talaq ba'in, and to pause and say, okay, what are the rules of talaq al-ba'in? And have to then it's good to just write down. In the talaq al-ba'in, for them to get together, this is required. You have to gather that. If it's fuzzy, you got to go back. Right? Otherwise, you don't know what's going on. Right? So, if a man divorces a woman with a talaq ba'in, ثم تزوجها في عدتها, and then he remarried her in her idda. وطلقها, and then he divorced her again. قبل أن يدخل, before he's consummated the marriage. Or أو يختلي, or for him to be alone with her. يختلي بها فعليه مهر كامل, a whole mahar is due. وعليها عدة المستقبلة, and she must perform another idda. Right? وقال محمد لها نصف المهر, and Imam Muhammad said half the mahar is due from her. وعليها إتمام العدة الأولى, and Imam Muhammad said she must complete the first idda, because she was still in that idda. But the relied upon position is that of Imam Abu Hanifa and his two companions. And we won't go into the legal thinking behind that too much, but it's there. Now, what if she has a child, so she wasn't apparently pregnant, right? Because if she was known to be pregnant, what would her idda be?
The end of the pregnancy.
The end of the pregnancy. Now, very interesting scenario, right? He says, ويثبت نسب ولد المطلقة الرجعية إذا جاءت به لسنتين أو أكثر. Right? The lineage of a child from one who is divorced with a revocable divorce is affirmed if she gives birth to him even two years after the marriage or longer. Why? Why? Because in the talaq al-raj'i, is it, so he divorced her once, right? Is intercourse allowed during the talaq al-raj'i? During the idda of the talaq al-raj'i? You don't have to take her back. It's recommended to take her back explicitly and then have relations, but is intercourse permitted in a talaq al-raj'i, in the idda of a talaq al-raj'i? Yes, it is, because it counts as ruju'. Now, the sunnah would be to have an explicit raj'a in that, but if it takes place, it counts, right? So there's a possibility that that took place. They didn't make it public. ما لم تقر بانقضاء عدتها, unless she admits to her idda having been complete. Okay? Because she already affirmed, so she said, my idda is over. Because there's a child's interest too. To the extent, the asl is إضافة الولد للزوجية. The basis is that we ascribe we ascribe the marriage, that is my we ascribe the child to the marriage, right? And it's in his interest to be ascribed to the marriage. So here, what's the issue? She got divorced. She did not say that her idda is over. And then she has a child. Even 2 years later, they'd be willing to accept that from the marriage, because it could have been that they got together. They didn't tell anybody, because you don't have to announce that you came back together. Right? Now, diyanatan, are you allowed to do that? So in court, the judge would say, would accept that. Diyanatan, because there's a consideration of truth, but there's also a consideration of the interest of the child. So it may be a case of satr. Consider that for the sake of the child, right? وإن جاءت به لأقل من سنتين بانت منه. But if the child is born less than 2 years after the talaq al-raj'i, that is considered a baynuna. right? Meaning that once the idda is over, if that's considered to be a talaq ba'in, it's you know, because it was raj'i, right? And the nasab is still established, right? So in the case it came for more than 2 years, we would just assume that they came back together. Because the fuqaha said that it's not conceivable that a child be born more than 2 years after pregnancy. Now, what's the role of science in that? All kinds of things science says that's not possible, but that keep happening, right? A lady in India gave birth at the age of 72 to twins this last week. He asked, he said, can women over X age give birth? He said no, but there are rare cases where it can happen, right? Because like a hukm adi, science tells you hukm adi, could there be a break in ada? Possibly. We don't expect it, but if it happens, it could happen. So after 2 years, the child, and they say it's from our marriage. It's as if implicitly they're saying that we got back together. Right? So the assumption would be حملا لتصرفهم على الصلاح. Right? So what's the issue? Zubayr and Zubaydah got married. September 1st, Zubayr divorces Zubaydah. Talaq raj'i. 2.5 years later, so right now we're in September 2019. 2 years later would be around March 2021. Right? Yeah? 2022. Right? She says this child is whose? Is Zubayr's. She hadn't ever declared that her idda is over. Why wouldn't she declare her idda is over? Unlearned. In Damascus, we used to have class daily in front of Shaykh Abdul Razak al-Halabi's office. It's like you live Allah subhanahu wa ta'ala's love for the common person, right? Abraham Lincoln's alleged to have said, God loves the common man, that's why he made so many of them. People do all kinds of weird and wacky things. I didn't know how to tell people how my idda. It was never over. I don't know when it was over. Says, but this child is from him? Yes. Okay. It's his child. Presumably they had intercourse at some point, and the idda, which ended the talaq raj'i, and the child is ascribed to what? But إن جاءت به لأقل من سنتين بانت منه. But he is born less than 2 years from them, and they don't admit to ending the talaq al-raj'i, then this will be considered baynuna. It's conceivable that the maximum period of haml, the fuqaha said, is 2 years. So if you divorce her with a revocable divorce, September 2019, anything less than 2 years from now, it is theoretically ascribable to the marriage. So he divorced her, she has a child less than 2 years from now, and she says it's Zubayr. Who said, okay, in Zubayr's, less than 2 years from now, she got pregnant during the marriage. Because if it happened after because she's not declared that her idda finished. She's not saying that there was zina took place between them. So he said, okay, no zina took place, hamlan ala, tasarruf, interpreting their state to be wholesome, and then that giving birth would be considered the end of the idda, and when the idda is over, it's considered like a baynuna, it's called baynuna sughra, a lesser parting. Because once the talaq al-raj'i, once its idda is over, now the opportunity of raj'a is over. It then becomes like a ba'in, and it's called a baynuna. And then, how do they get back together? New nikah is required. Okay. وإن جاءت به لأكثر من سنتين ثبت نسبه وكان رجع. But if she gives birth to him after 2 years from the talaq al-raj'i, then the lineage is established, and that taking place is considered to be like a raja in the case that we mentioned, right? That presumably at some point during their talaq, during their idda, they got back together. Right? Now in court, the qadi doesn't have to say, so, did you touch her with desire? Did you kiss her passionately? Did you, like, because if you say A and B, right, you say, she did not declare her idda was over, in other ways. They did not say that it's zina. They said the child is ours. And at some point that raj'a took place. Because we would, if we can interpret it as not being zina, then we would. Now, in some cases there, do they have to speak the truth in there? Sometimes, no. Because if this would be astar, this preserves their public dignity and preserves the child's dignity. They're not denying a third party their rights. Right? Right? So, in a situation like that, preservation of honor of one's good name is a sufficient basis for making a lie. When you're not, it's not a situation where it has to do with defending the rights of another. Right? So if Zubayr took $500 from you, he can't lie that, no, I didn't, sir, because he's denying you your rights. Or if Zubayr beat you up every other day, and you go to Qadi Umar, and he asks him, and Zubayr says, no, I never hit Hamza. He also preserve his good name. That's denying you your right for redress. Right? So the rights of a third party don't relate. So here, there's the interest of the child for it to be considered from the marriage, and the interest of the two parties. Right? So those are very delicate cases. Right? These are delicate cases, but sometimes that's what asatru rahma, right? The concealing is mercy. Sometimes too much truth is unmerciful. But satr that denies justice is not mercy. Okay. So that's in the talaq al-raj'i, because they could have come back together without requiring nikah. Right? Because if they claim nikah, then you say, okay, where are the shuhud, etc., etc. But al-mabtutatu, then he says, wal-mabtutatu yathbutu nasabu waladiha idha ja'at bihi li'aqalla min sanatayn. The one who was divorced, talaq ba'in, the lineage is established if she gives birth to him, to the child, less than 2 years from the divorce. Because then it's still ascribable to the marriage. If they claim it's from the marriage. If they claim it's from the marriage, right? And that, of course, will also return to the regulations of can you claim that in a particular Muslim country? So there's two things. One is qada'an, what could you claim? That returns to the laws of the land you're in. Okay? And if in a Muslim country they require verification of that. But diyanatan, you could claim the child in that kind of situation. وإن جاءت به لتمام سنتين من يوم الفرقة لم يثبت نسبه. And if she gives birth to him in the talaq al-ba'in, more than 2 years after the divorce took place, then the nasab, the lineage from the divorcing party would not be established. إلا أن يدعيه, unless he claims that that child is mine. He says, no, it's mine. Right? And then that of course raises issues. Then, did you guys remarry, etc.? That would require verification. ويثبت نسب ولد المتوفى عنها زوجها ما بين الوفاة وبين السنتين. And like the talaq al-ba'in is the one whose husband has died. You know that if a child is born less than 2 years from his death, the lineage would be established from him. Now, some of the contemporary Hanafis have disputed that according to doctors and scientists, the longest possible period would be, the longest possible pregnancy would be this much. So, what implication does that have upon divorce? Upon inscription of lineage? That's something that would be a good question to ask some of the senior ulama. Right, that here, you guys want to do a practice istifta question, to turn this into an istifta question that the Hanafi scholars say to find an explicit text that what's the longest أدنى مدة الحمل سنتين. The longest pregnancy is 2 years. They say that, and it has implications on Idda and inscription of lineage, as we see here. Now, in light of modern scientific, you just do a Google search, find something scientific looking, that according to the Royal Journal of God knows what, is this? What implication is that? And there's a lot of, and there's active discussion on this. But the fuqaha, like for the purpose, something that is practically, they say, look, allow the possibility of settle. Mistakes can happen, but where you could mind the interest of the child in a reasonable way. And there's many examples of that from the Sunnah, right? One of the Sahaba was away, and he said he not had relations with his wife, came back, and she gave birth to a child. He went to the Prophet ﷺ to complain. The Prophet ﷺ said, it was Firash. He was hesitant, and he suspected somebody, and even felt that the child looked like that man. But he accepted the child as his own, and that's rahmah. So there's no need to go to do DNA testing, etc. Sometimes some truth hurts. So how are you going to live with that hurt? Right? So that's something to keep in mind. وإذا اعترفت المعتدة بانقضاء عدتها, but if the woman in idda, whether talaq raj'i or ba'in, or she, the talaq of death, the idda from a talaq raj'i or ba'in, or from the death of the husband, that's why the author said, the commentator says mutlaqan, meaning in all three types of idda. If she says that her idda was over, ثم جاءت بولد لأقل من 6 أشهر. She says, my idda was over. And then the child is born less than 6 months, right? From then, ثبت نسبه. Then the lineage is established, because less than 6 months, it must be from what? From the pregnancy. Because the fuqaha said that أقل مدة الحمل 6 أشهر. The least time of pregnancy would be 6 months. But the problem is, she says my idda was over. But then the child is born for less than 6 months, means she must be lying. Because if she were, it's not possible for her to menstruate, to have, if she's pregnant, even if she experiences blood, is that considered the menstrual hayd? No. Any bleeding seen by the pregnant woman, even if it's على هيئة الحيض يعتبر نفاسا. يعتبر استحاضة. Considered استحاضة. She says my idda was over. But she has a child less than 6 months from the marriage. Because why? Because she doesn't want the child to be ascribed to that man, let's say, or whatever other, or she is confused. That's ignored. وإن جاءت به لستة أشهر. She delivers the child more than 6 months after لم يثبت نسبه. So what's the case? And this is why it's good to write this down, right? So what's the surah al-mas'ala? The surah al-mas'ala is as described, right? She says her idda is over in any of the divorces. Then, if she gives birth to a child less than 6 months from that, the child could only be ascribed to that marriage. She couldn't have had him from outside of that marriage. If it happens for more than 6 months, there's a possibility that it could be from someone else. Okay? Then the lineage will not be established to the previous husband. Okay? وإذا ولدت المعتدة ولدت. If the woman in Idda gives birth to a child, and this issue, the case here is, as the commentator adds an important proviso, وجحدت ولادته. She said, I gave birth. But people are denying that she gave birth. Right? لم يثبت نسبه عند أبي حنيفة. But then the lineage would not be established according to Abu Hanifa إلا, except with proof. أن يشهد بولادتها رجلان أو رجل وامرأتان, unless there are 2 men or 1 man and 2 women who bear witness that she gave birth. Right? Because she's making a claim. إلا أن يكون هناك حبل ظاهر, unless there was manifest pregnancy. So people would go, she's obviously pregnant. Right? أو اعتراف من قبل الزوج, or the husband had admitted to pregnancy. فيثبت النسب من غير شهادة. Then the lineage will be established without witnessing. Right? And then and if at any point the husband said that my wife is pregnant, that's considered إقرار. And there's an important principle, as we'll see in the section on bearing witness, that لا يصح الرجوع عن إقرار. One cannot go back on an admission. Right? So divorce Zubaydah says, she looked really ugly when she was pregnant. But she's pregnant. It says she wasn't pregnant. You can't do that. Okay? وقال يثبت في الجميع بشهادة امرأة واحدة. And they said that just the witness of 1 woman is sufficient. Right? Because these are things that men do not normally see, the delivering of child. But usually men are around somewhere. Like it doesn't. And it's Abu Hanifa's position's the default here as well. We have a few more issues left, but we will pause here so that people have time to get home for Maghrib. وصلى الله على سيدنا محمد وعلى آله وصحبه وسلم. والحمد لله رب العالمين. So we have just a couple of issues left for nikah, and then we have nafaqat. Nafaqat and hadana. We'll try to have need 2 heavy classes to get through this.